So here our plan for the next 60 minutes, and there are total 7 topics that I'm going to discuss today. So the first one is, what are intellectual property rights? What is patent? How patent companies work? What is patentability search? What is freedom to operate? What is invalidity search? And at last, how all these things are interconnected with each other. Now let's start with the very first topic, that is intellectual property rights. So every one of you on your phone, right? You own your bag, you own your bike, and these are physical things. You can touch them, you can show them to people, and if someone steals them, you can go to the police. Now, what if you create something with your mind? A song you wrote, a logo you designed, a formula you discovered in your lab, a mobile app you built. Can you own those too? And the answer is yes. You absolutely can, and that is called intellectual property rights. So if I tell in simple words, anything you create with your brain that has some value, just like physical property, you can own it, you can sell it, and it can be protected by the law. And here, IP is not one single thing. It is a family of 4 different types of protections. So let's meet with each one with examples that you already know from daily life. So these are the 4 pillars of intellectual property. The first one is copyright. So what is copyright? It protects original creative work, like your songs, writing, music, any software code, or photographs. Let me explain with the example of T-series songs. So every T-series song on YouTube is copyrighted, right? If you download it and upload it on your own channel without permission, that is a violation. So copyright exists automatically the moment you create something. You don't even need to register it. So might be many of you are a researcher as well, write some papers. So in case of that also, if you write a research paper, it is automatically copyrighted. If a journal or another researcher copies your paper without permission, that is a copyright violation. And the duration of this copyright is still the life of the creator or the 70 years. The second pillar of intellectual property is trademark. So trademark protects the brand identity, the names, the logos, the slogans, and even the sounds. So if I explain with example like Nike shoes, McDonald's Arcades, Intel jingle, Amul girl, all these are the trademarks. And its duration is forever. As long as you keep renewing it for every 10 years, it will be there with you. If I'll give you example of any pharma drug, then you see that there are various drugs with different brands like Crocin, Dolo. All these are the trademarks. These are the active drug in this is paracetamol, but the brand name belongs to the company. So this is also a trademark. The next is a trade secret. Trade secret protects the confidential business information that gives a competitive advantage. So basically, it covers the secret business information that kept hidden and not registered. A very common example is Coca-Cola formula. They have never patented this formula. Why? Because if you patent it, you must tell the world how it made. And after 20 years, anyone can copy it. So instead, they kept it a secret for 130 years. Only 2 people know the full formula at any time, and it's stored in a bank vault in Atlanta. Similarly, many pharma companies protect their manufacturing processes as trade secrets, especially how they make the complex biological drugs, because the how is extremely hard to reverse engineer. And its duration is also forever, but only as long as the secret kept as secret, and the day it leaks, the protection is gone. And fourth and most important pillar of intellectual property is patent. So the patents protects the inventions, the new processes, the machines, the products, the composition of matter, everything. So if I explain this with an example, so it's very common example of Amazon one click. So Amazon patented this feature that is buy with one click. That idea that you could purchase something online with literally one click, it's a very simple idea. But Apple had to pay Amazon millions of rupees in licensing fees just to use it on iTunes. So you can see that one patent is equal to crores in royalties. In pharma domain also, every new drug formulation, every new drug molecule, every new way of making a medicine is protected by patents. And this is the biggest patent industry in the world. The duration of the patent is 20 years, and after that, anyone can use it freely. So IP is all around you. Look at your phone right now, and I mean it, actually look at it. That one device in your hand has hundreds of active patents inside it. The way the screen responds to your touch, the face unlock system, the camera autofocus, the notification sound, the brand name on the back, and every single thing is protected by some form of IP. So here are some examples. For example, in WhatsApp lock icon, so the end-to-end encryption protocol is patented by Meta. Every time you send a message by using this WhatsApp, you are using a patented technology. Another example is a Coca-Cola formula that I already discussed, T-series songs, and the Nike shoes. Now, out of all these intellectual property rights, why the patent is most special, and what are the key differences between all four IPs? So the big difference is that copyright protects your work and you don't have to explain anything to anyone. Trademark also protect your brand, but you don't need to explain anything to anyone. And trade secret protect your formula. You actively hide everything. But what about the patent? Patent says, tell the world exactly how your invention works, and in return, we give you 20 years of protection. So patent is the only IP that requires you to publicly teach your invention in exchange for protection. And that is a deal for 20 years of monopoly for disclosing your knowledge to the world. So I don't think here you guys need an example, but still I'll give you a very simple example that everyone can relate to. So when a drug, let's suppose a Lipitor is a drug, was under patent, only Pfizer could sell it. And it cost at around 200 rupees per tablet. But when the patent expired after 20 years, 50 plus generic companies launched the same molecule and the price dropped to rupees 2 per tablet. So that is the patent deal working for society. Now, what exactly is a patent? If I tell you the formal definition, a patent is a legal right that is given by the government to the inventor for 20 years and in exchange for publicly explaining how the invention works. And during those 20 years, only the inventor can make, sell, or use that invention. And in patent, there are three magic words. The first one is novel, second is non-obvious, and third is useful. Novel means it should be completely new. Nobody in the world has ever done this before. Non-obvious means not just new, it must be genuine inventive step, not an obvious next step. And useful means it must have a real practical use in a world and not just a theory. So let me explain with you a very simple story. Let's discuss with a chocolate story that will make the entire patent process crystal clear for you guys. So imagine you have a chocolate and you love chocolates. You spend 3 years in your kitchen and you spend 50 lakhs, and finally you create a chocolate that doesn't melt even at 50 degrees Celsius. So this is your invention. Nobody has ever done this before, and this is genuinely new. What do you do next? If you invent something, you will file that invention, right? You go to the patent office, you submit a detailed application, you explain exactly how you made it. Every ingredient, every temperature, and every step. You don't just say, I made a chocolate, you teach the world your recipe. The patent office or the government review your application and ask you 3 questions. The first question, is it new? The second question, is it non-obvious or is it genuine? And the third question is it useful? And if all 3 questions are yes, then congratulations, you get your patent. Now, you get the rights for 20 years. Only you can make and sell this for 20 years. Other competitors, like if Cadbury wants it, they must take a license from you and pay you royalties. And if Amul wants it, same deal goes with them. You are the monopoly holder. And in exchange of this, what in return, your full recipe is now publicly published. After 20 years, anyone in the world can make your melt-proof chocolate for free. So society benefits from your knowledge. I'll explain with a real example that Amazon one-click patent in 1999. Amazon patented buy with one click, and it's a simple idea that I already discussed, but nobody has done it before. Apple had to pay Amazon millions in licensing fees just to use it on iTunes. And this is the power of well-timed patent. So what are the conditions to get a patent? As I already discussed, it should be novel, it should be non-obvious, it should be useful. So if I explain the novelty, your invention must be completely new, not done before anywhere in the world, not in a paper, not in an early patent, not demonstrated publicly. You must file the patent before you present at a conference or publish your paper. And many researchers lose their patent right because they publish first. And once it's publicly available, it is no longer be novel. The second condition is it should be non-obvious. Non-obvious means it must represent a real inventive step, not something any trained professional would immediately think of. Right? For example, if someone combined a phone with fingerprint sensor in 2010, so it's something that is new. No one had done this before. So it is non-obvious. Then, if someone combine a phone with a charger cable, it's something that is very obvious. So you will not get patent on the obvious things. If I give another example, let's suppose in pharma domain, we are making a tablet that dissolves in 30 seconds instead of 5 minutes using a completely new polymer combination. So here the polymer combination is something that no one can think of. So it's non-obvious. But if I simply make a coating over a tablet with a non-coating agent, that is obvious. You will not get patent on this. So your invention must be non-obvious. It should not be obvious for everyone. The third thing is useful. The invention must have a clear, practical, real-world use. You cannot patent a mathematical formula or a law of nature in its pure form. For example, you cannot patent E is equal to mc square, that is mass energy equivalence, introduced by Albert Einstein, and that's the law of nature. But if you use this physics to build a specific new type of battery with a specific design, that specific battery can be patented. Another example I'll give you is that if you cannot patent a natural compound found in a plant just as it exists. But a specific method to extract it, purify it, and use it as a medicine, that can be patented. So everything you patent, it must be useful. So next is the anatomy of the patent document. So there are 6 key parts in patents. You can also search in a Google form that Google patent, that is free of cost. Here, if in Google Chrome, if I write Google patents, we'll go to this page and Google patent browser is open. Here you can type anything, any invention. Even you can write here Swiggy, Zomato, the Blinkit, anything. So here I'm typing as aerosol generating device. So we'll get almost 1 lakh of patents on this. So if I open the patent, this is the whole patent. and you can see there are different parts of patent. It's like a research paper. So, but it is mixed with a legal contract. You just understand how it works. So the first thing, that is aerosol generating device, it's the title of the patent, similar to the research paper. The second part is the abstract, where it's a short summary or summary in a plain language. That is what you read first to decide if the patent is relevant to you or not. Why? Because it is a summary of whole invention. You will get an idea that what this invention is talking about. Then you can see here, this is a patent number. EP is a European code, that is, it's a European patent. And here is a list of inventors. So inventors are those who came up with this idea. And assignee, that is the owner of the patent. Here is a Nico Ventures Trading is the assignee of the patent. They filed the patent on 9th of March 2020, and this patent is published on 24th of March 2021. Now this is a description part. So this is a full technical explanation. This is where the inventor teaches the world everything, every step. So the public disclosure part of the deal is here, the description part. And here is the claims. Claims, that is the most important part of our patent. It's a legal fence around the invention. Means it defines exactly what is protected. So if your product falls inside this fence, you are infringing the patent. And at last, there are some citations, means the inventions that are already existing before this patent, similar to the references that we have given during our research paper or anything. So these are the patent citations or references. So this is the whole anatomy of the patent document. Now the most important question is how patent companies work. Now you understand what the patent is, but who actually does all this work, who searches for patent, who writes them, and who fights over them in court, it's also very important. And that's where patent companies come in. And I'll explain you a simple way to understand what they do. So think of a patent company like a hospital. Hospital treats sick patients, and a patent company solves IP problems for businesses, just like a hospital has different specialists like cardiologist, surgeon, radiologist. A patent company has different experts like search analyst, drafting specialist, litigation support team. So everyone is doing their work here. And just like you don't go to the hospital until you have a problem, businesses come to patent companies when they have an IP problem or an IP opportunity. Now the question is, who hires the patent companies? Who are the clients of patent companies? So let me walk you through the most common ones. The first one is tech startups. For example, Zomato builds a new AI algorithm for deliver route optimization. But before they file a patent, they hire a patent company to check if the idea is truly new. So it's very important to know, because the filing of patent costs around 50,000 to 5 lakh rupees. So it's very important to know whether it's worth filing or not before spending that money. So they hire the patent companies to do this type of research. Another is pharma company. If Sun Pharma needs to protect a new drug formulation, they came to the patent companies. Automobile manufacturers, Tata Motors file a patent for EV battery or cooling tech. So they also come to the patent companies. Some universities, for example, IIT Delhi, develop a new water purification membrane and they want to patent it and license it to the companies, but they need help with the entire process. So patent companies help universities to monetize their research. And last and most important clients of patent companies are law firms. Let me explain with you example. For example, a Delhi IP law firm is fighting a court case and they need evidence to prove a competitor's patent is invalid. They hired a patent analyst to find that evidence. So patent litigation is extremely expensive. One good piece of prior art found by an analyst can save crores in code. So law firms are the biggest clients of patent companies. All these are the clients, but law firms are the biggest client, and other tech startup, pharma companies, auto manufacturers, some universities, all these are the clients of patent companies. Now in patent companies, there are three types of searches that we are doing. The first kind of search is patentability search. So what it is, imagine you have a brilliant idea. You have worked on it for months. You want to patent it. But before you spend 50,000 to 5 lakh rupees of filing a patent, wouldn't you want to know, has someone already done this? And client says, ask exactly same. I have a new idea, can I actually patent it? So that's exactly what a patentability search does. In patentability search, we look through all published patents, all research papers, all public documents to check if your invention is truly new or not before you spend money for filing. Now, 5 reasons why clients do a patentability search. So smart companies always do this search first. Why? The first thing is save money. Filing cost is too much. Second, save years of time, because patent processing takes time to 2 to 5 years, and knowing early whether it is worth pursuing saves year of false hope and wasted efforts. The third is improve the invention. Even if similar patents sometimes exist, the search reveals the gap. So we as an analyst tells the clients that your basic idea is taken, but this variation is still open. You can modify your patent, you can modify your invention and file a stronger patent. The fourth is to avoid accidental copying. If you build a product that copies the patented technology, you can be sued. So search first is most important in that case as well. So prevention is far cheaper than litigation. And the last is investor confidence. So investor usually ask, is this patentable? What is your IP moat? A search report in hand shows seriousness. Many funds will not invest without IP clarity. So these are the 5 reasons the clients do a patentability search. So I'll explain you with example. Let's suppose the client came to us and says that I made a smart water bottle that reminds you to drink by smartphone app. Can I patent this? So how will a research analyst find it? So this is a very basic example, or I'll give you a demonstration. This is very basic. We'll do so much deeper than this, but I'll explain you. You can also do this thing with me. Go to the Google Patents. Similar way, type Google Patents here. And then type Smart Water Bottle Hydration Reminder app and search. So you see here, there are total 604 results. So it means that this field is very active, but still we can search targeted. Like we can use some Boolean operator, because it's very difficult to read all the 604 patents. Might be some are irrelevant. Then the next step, what we do, will make a string that is more targeted. For example, here we search by this string, smart water bottle, and that is a Boolean operator, hydration reminder or drink notification, and smartphone. Then we search and we find there are only 3 patents here. When we open the patent, the similar thing, you can see here is a title, abstract. We read the abstract and we find that yes, there is a smart drinking container that is similar to our invention. And this patent almost discloses all the features that client want to patent. Now, this patent is very close to our client's idea. Now, what we do next? We'll give client option, like either do not patent this invention or to change something. After that, what we do? we use different perspectives and we add if there is anything or any smart water bottle that is also combine or cover the AI personalized reminders using body weight, activity, and climate data together. And we found that there is no patent on this technology. So what we do, we tell the client that yes, the idea that the client is given is cannot be patented because it's already existed, but client can modify their invention by including these features, and there is no patent on this. So this version can be patented. So this is the example of patentability search. Now, second type of search that we do in patent companies, that is freedom to operate. Now imagine here you have built a product, you're ready to launch that product and you're very excited. But before you launch, someone asks you, are you sure no one else owns a patent that covers your product? So that's what the freedom to operate check is about. A freedom to operate analysis checks all the active patents in a country to make sure that the product you are launching is not going to infringe any of the patent. So it is very important. If I'll tell you the definition of this freedom to operate, so it's analysis of searches of all the active patents in a given territory to determine whether a company can commercialize its product without infringing any existing patent or not. So it should be done before launch of the product. Because there is an example where Samsung paid Apple 1 billion USDs because they launched the product without proper FTO search. So FTO is one of the most important searches that can be done before launching a product. Now, people often mix up these two things, the FTO and the patentability. Patentability search is something that can be done before filing a patent. If I have some idea, if I invented something and I want to file it, I will do patentability search first because filing cost is also very high. And why I did this patentability search? To check, is my idea novel, new or not? But if I'm talking about freedom to operate, here I'm not going to patent anything. I just make a product and I want to sell in a market. But before launching that product, I want to know whether my product infringes someone's patent or not. Or any patent do block me in future. Because if it happens, it will lead to a huge damage. I'll have to pay so much amount to the company whose patent I will infringe. So these are the two different types of searches. These are some real cases of FTO where the people skip FTO and they have to pay a huge amount. Samsung versus Apple, $1 billion. Apple sued the Samsung in 2011 because Samsung's phones infringed the Apple's bounce back scrolling and pinch to zoom patents. So jury awarded Apple $1 billion. Samsung had to redesign the multiple product lines. And the lesson is a pre-launch FTO would have flagged those patents before the feature was built. The second is BlackBerry versus NTP. So NTP held a patent on wireless email delivery and the core of BlackBerry business. BlackBerry paid $612 million to settle. So NTP never made a single product, they just held the patents, right? And this is something that is different because BlackBerry had no FTO clearance before building their flagship services. And this type of case, we can create a term that is patent troll. Some companies are there that hold the patent just to sue the others. They don't make the product, they just have a patent and they just sue the other company if any other company makes the product on similar technology. And there are some other companies or Indian startup that, without FTO, they will have to face a huge loss. So one Indian startup built up a smart doorbell with facial recognition. And after raising 5 crore and shipping 10,000 units, They received a notice from US company holding a patent on AI facial recognition for access control. So they have to shut down their startup. So if they did FTO, they would have flagged the US patent before a single unit was manufactured, and they can prevent this loss. So these are the real case examples where without FTO, the companies have to face a huge loss. This is another example. So here also, there is a startup company that is FlexPhone. They're about to launch a foldable display phone in India and US. This is example of FTO search. So let's suppose the company came to us and they make a product that is a display phone, and it is a foldable phone. And they want to launch this product in India and US. They ask us, are we safe? So here is a time to do FTO search. And when we search for this kind of features, what we found that yes, there is a one patent in US. That is the Samsung's patent, and it discloses a flexible display hinge mechanism for mobile device, and it is active until 2037. Now this FlexPhone's hinge design likely infringed the claim 1. It means either the FlexPhone startup company has to redesign the hinge, or they should have purchased the license from Samsung. We then search more and we find another patent from Motorola. Here the basic foldable form factor is there, but this patent has been expired. So yes, I already told if the patent is expired, now the information is in public domain and anyone can use that. So there is no risk from this patent to the client. Another patent is from Chinese patent, and here also they describe a feature that is organic light emitting display folding method. But this patent is active in China only. Now this patent is in China and we want to launch our product in India and US, then there is no risk. If we expand our product to China, then it will create some kind of risk, because right now we are going to launch in India and US, so this patent is also of no risk. Now what are the recommendations from our side to client? Either the client should redesign the hinge to design around the Samsung patent, or the client should take the license from the Samsung, or the third important thing that the client can do is invalidity search. And here we are in the next slide, where we are going to discuss about the third and most important search in patent companies, that is invalidity search. Now you can imagine a very worst case scenario. You built a product, you launched it, business is going well, and then one morning you get a legal notice. A competitor says you are using our patent, pay us 50 crore or shut down. Now what do? You fight back, and the weapon you use is called an invalidity search. So invalidity search looks for the evidence that the competitor's patent should never have been granted in the first place, because the invention was not truly known when they filed it. If you find that evidence, the patent is cancelled, the lawsuit disappears. One single document, a single prior art document found by the patent analyst can overturn a patent and save a company for crores in damages. So there are different grounds how we can invalidate a patent. Someone claims they were for example, this is an analogy that I'll explain you. Someone claims that they were the first person to eat pizza and tries to own the word pizza. What you do, you pull out a book, 1985 Italian cookbook, and that is published before their claim. That cookbook is a prior art here. It proves the invention existed before their patent, and the patent is invalid. Invalidity search work means we have to find some kind of prior art that is existed before the patent so that we can invalidate that patent. And there are 4 different grounds. We can find out any prior art publication, any publication before the patent filing date, a paper, a patent, a blog, even a YouTube music describing the invention. So this can be used as a prior art. If there is any earlier patent, this is a second ground. Another patent that is filed earlier already covered the same invention. The examiner missed it, but we found it. This is a second ground of invalidity. The third is prior public use. If inventor sold or publicly demonstrate the invention more than 1 year before the filing, for example, some in trade show, someone show their product before, and then he or she will file this invention more after 1 year. Then what happens? It breaks the novelty. This ground can also be used for invalidity. And the last one is obvious combination. If someone combine the two things and take a patent over this, then it can be one of the grounds to invalidate the patent. Now, this is a very common example of invalidity. That is Apple's slide to unlock patent. What happened? Samsung is sued for infringing Apple's US patent, that is slide to unlock patent. What happened? Samsung used this feature, that is slide to unlock. When Apple get to know about this, Apple sued the Samsung. Why? Because Apple has already a patent over this that is filed in 2005. Now Samsung came to us like their invention infringed the Apple's patent. What we can do? So our job is to invalidate the Apple's patent. If we find out any prior art before 2005, we can invalidate the Apple's patent so that the Samsung is free to use free to sell their product. So what we do first? We first go to the Google Patents and insert this patent number. We read the claim. Let's suppose the claim 1 says a method of unlocking a handheld device by moving a graphical image along a predefined path on a touch screen. So here we get the novel feature, like the core feature is sliding a graphical element to unlock. Now search for this before 2005. We use a date filter. We use different databases. Google Patent is the most common, but other databases are also there, like the Event, the Orbit. We use all these databases and apply a filter before 2005. We can also check YouTube videos. We can also check the Google Scholar. And what we found, there is one company that is Neonode N1M. They have a Swedish phone 2002, and this phone have a similar feature, swipe to unlock. Also, we found an academic paper in Google Scholar describing sliding lock mechanism. So both of these arts or these informations are publicly available before 2005. So what we do next? We present this evidence in a court. Present Neonode product brochure or 2004 academic paper as a prior art, and we argue that this concept existed before Apple's filing. And what is the outcome we get? The courts in Germany, Netherlands, and UK found Apple's slide to unlock patent invalid. So now Samsung's invalidity argument worked. Samsung is free to sell their product. Now, how all these things are interconnected? This is very important. So we have covered a lot today. Let me show you how all these things are actually interconnected. The first is, there are 3 questions already. 1 invention, 3 different client questions, and 3 different services that patent companies offer. The first thing, can I patent it? So for this we do the patentability search. Second question, can I sell it safely? For this, we do the freedom to operate search. Launch safe, so that client can launch safely and redesign the product if needed. And the third type is fight their patent. That is invalidity search. So a competitor is suing any company with their patent. So can I fight back? So this kind of search is invalidity search, to find a prior art and destroy the patent, win in the court. We are almost at the end of the session, and here are 3 things I want you to carry with you from today. The first thing is IP protects the value of your ideas. Copyright, trademark, trade secret, patent, each protect a different kind of creation. Understanding which one apply to your work is the first step to protecting it. You create it, you own it. So you can open your favorite app tonight and ask what IP protects this. Either it is a trademark, it is a copyright, or it's a patent. The second is patent companies are problem solvers. They answer three critical questions. Can I patent it? Can I sell it safely? Can I fight back? And each answer backed by a deep research. Each can save or make a company crores of rupees. So remember these three things: patentability, FTO, and invalidity, three services provided by the patent companies. And last is your journey starts from tonight. You can open the Google patent. You can search any product that you like. So if you read the abstract and claims, it will take you hardly the 30 minutes and you will get a real understanding of IP. So if you have any questions, you can ask in chat box. Thank you so much.